All right, here we go. We're getting into chapter 1 of your book. And this is all talking about, again, law, the definition of law. And as I stated in the intro, that we've all had some kind of a experience with law. Uh, your book talks about the definitions, and I'll talk about two of them, or three, where Aristotle says that it's the law unaffected by desire. Well, I kind of agree and disagree with that because when our forefathers started uh, to have our own constitution here, which were the Bill of Rights and the Constitution, they had a purpose, and it was their desire to be able to be taxed with representation, their desire to worship freely. So, desire to me, and you're gonna start noticing that I do voice some of my opinions on here. And again, my opinions, you don't have to agree with them. The other one is where we talk about where Oliver Wendell Holmes talk about um, that it's a story that embodies the nation's development through many centuries. And I kind of like that. The reason I kind of like that is because it shows how we progressed, how the law and the interpretation of law has had to deal with many of the things that are going on right now. The changes in technology. I mean, I remember not me personally. I mean, I'm old, but not that old to remember how the Industrial Revolution started. But reading about it and understanding it, how all those laws had to come in place concerning copyright law because now they're actually mass producing things, patents, who owns what. Is it the idea that somebody knows? Is it a patent law? Is it a copyright law? Is it a trademark? Is it um, um, a registered trademark? Is it what is it? And how do we protect it? How do we protect ourselves? So again, they talk about different things, and one of the other things that Black's Law Dictionary defines law as a um, body of rules of action or conduct prescribed by controlling authority and having legal and binding force. Well, that legal and binding force depends on the defender and the prosecutor. Because remember, as I was reminded this past 2 weeks, that a person is innocent until determined guilty in a court of law. And it's one of the things that we were promised is a jury trial by our peers. And of course, they get the lawyers, the defenders, and the prosecutors get to determine who that's going to be. um, and I'll tell you a little story about that in a second. So we have classifications of law as well. Now they're talking about public versus private law. Public, of course, where you have your state and your federal laws, all the laws that are out there. Private law is where you still have a basis um, from law, but it's more of a agreement. But it's a private law, for example, between a rentor and a rentee, meaning the landlord and the person that's going to rent their house or apartment. There's a contract between them. There's a private law, an agreement of what's going to continue, what's going to be um, agreed upon by both. And the signing of that contract or private law by both parties and then getting it notarized shows that they both agree with it and they both were signing without being under duress, meaning that no one was making them sign it under, a gun to their head or anything like that. Um, that's what duress means, that they were under duress, that they were forced to sign without just wanting to force to sign without any force with their own volition. Um, the next thing that they talked about is criminal versus civil law, and that's what I actually experienced going to um, going to be a jury panelist at the Cameron County Courthouse. I thought I was saved from having to go to jury duty because I had already gone to try to be a jury panelist on a federal court. That didn't happen. So anyway, I go. The first one was a criminal case. The criminal case was where the they were doing their voir dire, giving us the information about the case. Where what it ended up happening is we were going to have to decide whether or not this person was guilty or not based on the charges, which were driving while intoxicated, of course, and then uh, then the other thing was intoxication assault and um, assault with a deadly weapon. So intoxication assault was where he was driving intoxicated. Uh, the assault with a deadly weapon was where they were trying to show that the car was a deadly weapon, but he was impaired. um, they were letting us know about the point where a person is legally drunk, which is point 0.08. And the defense was saying, yes, it's 0.08, but if it's 0.799999999, then it doesn't, the law doesn't round up. Why? I don't know. By the way, I don't round up in this course either. Um, the other thing that they were talking about was where they wanted to know whether we had a bias or not against people that had already done something like this. There was two panelists. Oh my gosh, I felt so bad for them because they had just recently, one had a niece that was just killed by a drunk driver. The other one had another one that had been killed by a drunk driver. So they wanted to know if the defender wanted to know, are you biased? And they said, yes, I am biased because of this, because of their experience. Again, that experience with the law. I didn't have a problem with trying to come to and being a jury panelist until that one point where they said that we were going to have to determine punishment, and that's what happens with a criminal case. Your book talks about punishment, penalty. So the penalty was, of course, a fine plus which was he was going to have to pay all court costs if he was found guilty. And then, of course, the other thing, which was going to be if he was found guilty of intoxication, um, assault, and assault with a deadly weapon, the criteria was that he could get anywhere between probation, or 2 to 20 years. So they were telling us about this, and I'm thinking, okay, great, no big deal. Uh, and then I said, raised my hand. I said, we're just recommending, correct? And then the judge says, no, you, the jurors, are going to decide the um, penalty based on the information and the evidence provided, the um, the uh, um, the priors, if the person had any priors. Nobody died in this case, but still it was difficult. So I went ahead and I said, do you have a problem with that? And I had to be very careful with my words. Because yeah, I had a problem with that. I had no rubric to go by. This means this means this means this. They're just, to me, it was too subjective. Uh, and you're talking about finding somebody guilty. And if you find somebody guilty, then saying, okay, I'm okay with giving him this kind of punishment. Um, no, I wasn't okay. So I voiced my opinion, I voiced my status, and I said I can't do it. Well, as soon as I said that I couldn't do it, I could see the lawyers going ahead and striking my name out. And that's what happened. Now, the next one that your book talks about is a civil law. Civil is where there's no criminal intent, no criminal action at all, no kind of a penalty as far as jail time uh, or fine. Instead, what they're trying to do is award for damages. For example, let's say that um, instead of a car wreck, well, this one was a car wreck as well, but they were talking about where this person wanted damages for the problem with his back that he had. Well, they were talking about how um, uh, the judge, the prosecutor, no, the defender gave a really good analysis. He said, okay, what happens if, let's say that we're coming to, we're at the hall and there's another hall where it meet. And let's say that I'm walking and you're walking, but you might be texting and you run into me. You spill my coffee and you get my shirt dirty. And he was saying, okay, so do you owe me coffee? Sure. Do you owe me cleaning my shirt? Okay. Well, if I got coffee from McDonald's, do you automatically owe me a Starbucks? And we are like, well, probably not. Okay, do you owe me to clean my shirt every single day for a year? Probably not. He was getting to how much is owed. How much should the um, award be? Well, being who I am, after he said that, I went ahead and I rose my jury card up because they give you a jury number. So he says, yes, number two, what seems to be your problem? Or you're not your problem, but my question. But I did have a problem. So my problem is this. How hot was the coffee? And he looks at me, he's like, what? So how hot was the coffee? Um, was the coffee in a styrofoam cup? Was it boiling? Was it in a Yeti? Was it in a thermos where it keeps its heat a lot longer? Was it a first degree burn? Did I have an undershirt? You know, was there any kind of, physical damage as well, or physical um, hurt? And again, I could see my name being crossed out, and kind of almost the minds of these people thinking, get her off the database. Um, so we went out after I asked that question, came back in, and we were going to be told who was selected. Well, they went from number one that was selected, and then they started going to number 15. So what they did is they said me and anybody else that sat around me that was being influenced, out of there. You're not going to be part of it. I could not stop laughing. But that was a valid question that I had to ask. Of course, the defense said, no way. We don't want her influencing the jurors at all. So that's criminal, and that's substantive law. I should be going through here as well. Um, Here we go. Now, the other thing also is the substances versus the procedural laws. Okay, that's where you give rights and responsibilities. Procedural means more of the enforcing the substantive rights, which means, again, um, showing where procedural enforcing the law, where if there's a contract that has been breached, you said you're going to do this, you said you're going to do this, and you haven't done it, that's where it comes in and says, wait, you said you're going to do this based off the contract. It needs to be enforced. You've got to do that, okay? And it's the responsibilities, going back to the landlord and the lease person, the rentor. I'm going to do this, and this. I'm going to provide you this, and you're going to pay me for that. So again, that's what substantive versus procedural laws actually mean. Common law began in England back in 1066, and it continues today. For example, okay, just to let you know, common law in the state of Texas means that if you're married by common law, you only have to be married for less than a month. The other thing that stands on the books, unless it's changed, that I don't know of, but the last time I checked, if you introduce each other as husband and wife, that's it. You're married in the eyes of Texas. Okay. It's also it exists. It's a non-statutory law. What that means, as far as a non-statutory law, it says that it is a it's not a result being passed by some government body uh, and written in some kind of form when it's created. It's something that's more of common. I hate to say this, but I'm going to, more of common law, common knowledge. Okay. Um, Even though you should run a stop sign. Okay. Um, you have your substantial law says that your responsibility is to stop. Right. Okay. If you don't stop, then procedure says you're going to get a ticket if the cop's there. So you're going to get a ticket. This is how it's going to be. This is what's going to happen. Da 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 da. Okay. It does exist for courts and courts decisions. It follows a case precedent, or stare decisis, let the decision stands. Okay. How it's going to stand, how it's going to be. Now, in the United States, we have common and statutory laws. Some of our common laws still exist. Um, And one of them is how we uh, own or pass real property um, that was established by English law. Now, remember, in English law, the only way that you could go ahead and pass legal property from one person to another was if you had a son. The son was the heir, not females. That changed. Thank God. Okay, that did change. Um, and of course, statutory law does exist in all levels of government, which is federal, state, county, and city, and borough and or town. Now, the reason they say borough and or town because of um, how it was set up in England. The other thing also again is that with statutory, it's also known as codified law, and that means again that it is already coded, written somewhere under some area. For example, you have your legal, you have your land, you have um, your educational law, civil law, criminal law. They're all in categories and codified as well. Law versus equity. In common law, England remedies were separated, meaning how are we going to remedy this? Um, Meaning again, okay, how much everything is valued. And again, going back to that I had to deal with, which was the portion of um, having to deal with the criminal cases, the what was going to happen there, who was going to pay the fines, who was going to do what in the civil case, how much award or damages were going to be provided, what was the value of the money that was going to be given based on his pain and suffering. Um, equitable again means this equals that. This is how you see this equals that. Remedies, of course, separated so that courts um, could give remedies when courts could not. Today, um, all of the courts are required to give um, the remedies, suitable and remedies with a jury panels. Now, sometimes those courts have a jury panel and sometimes they don't. For example, divorce proceedings. In divorce proceedings, usually it's just the person that the persons that are trying to get divorced and a judge, and the judge makes a decision of who's going to get what, why, where, and they're trying to make sure that they have equitable remedies as well. For example, if you have a house, if it's not going to be very clear and distinguished as to who's going to go ahead and end up with um, the title of the house, then what they decide is we're going to sell it and everybody's going to go ahead after everything is paid off. If there's anything that's owed, then everybody's going to get an equal share of what is there. Um, those type of classifications and those kind of remedies that are done. Okay, so this is the first portion of the classifications of law. Next, what we're going to be getting into is the purpose of law. Okay, it keeps order. It influences conduct, or it should influence conduct, right? It should honor expectations. I expect that if I buy a TV, it's not going to be wrecked. Um, it's going to work. If I buy a car, it's going to work the way it's supposed to. Remember, there is a lemon law that's out there to keep us from that. And now, because of that lemon law, if you want to sell a car and there's problems with it, but you really don't want to say what's there, you're protected under what is called as is. If it works, it works. If it doesn't work, it doesn't work. It's as is. Now, most people are going to let you know, hey, it's there, it'll work. It's give me the money for if you were to sell it to a junkyard, give me the money for the parts that do work. Give me the money for the sides, for setting it up into parts. Now, it does try to promote equality, okay? Um, so that everybody is equally represented again in the law. And the law is a great compromiser, um, where we all have to compromise. Now, my problem with compromising is that both parties have to give in order for there to be a compromise. But in some areas, the compromise portion is this: that if somebody is found guilty, the law is found as a great compromiser because the party that was wronged gets justice. Okay, and justice overall is supposed to be the greatest compromiser. And then it goes in, and based on whether or not the person is found guilty, then they determine, okay, um, how how long should they be in jail, yes or no. Now, not a lot of people agree with it. I understand that, but hey, this is what happens. Then you have the characteristics. It's flexible. Um, uh, because of the changes and the internet and people supposedly getting more informed, the flexibility is there, and so that you can revisit a contract. The consistency allows businesses to rely on the law for planning, meaning that it's going to allow you to understand, for everybody to understand, if this is consistent. If you rent something, you owe money, right? If you buy something, you expect it to work. um, Pervasiveness, of course, is um, where you are forming, and you're either forming a business, not, or you're disillusioning a business, or there's a dissolution of a corporation. For example, Toys R Us that was completely disillusioned, but guess what? It's coming back, supposedly, because during Christmas nobody knew where to buy their Christmas toys, really, with Amazon. But anyway, it's coming back. Um, the other thing, though, that it does not interfere with management and the flexibility of management when it's needed to. Okay, we're going to go through these cases that are here, um, and I'm going to go through them. So this is the beginnings of what's going on. Uh, this is the first portion of your lecture summary. I don't want to go continue on. I'm going to go ahead and stop it here, and then you're going to have your lecture summary 2. I'll see you on the flip side.